Okay, so I gotta catch up with the Daf Yomi here because this is the portion for May 31st, which was Shabbat. So this is after Shabbat. So here we go. This is Daf 30 of Shevuot. It says the Mishnah. So we're in a new Mishnah here. The oath of testimony is practiced with regard to men, but not with regard to women. With regard to non-relatives of litigants, but not with regard to relatives. With regard to those fit to testify, but not with those unfit to testify due to a transgression that they performed. And the oath of testimony is practiced only with regard to those fit to testify. So the oath of testimony is practiced both in the presence of a court and not in the presence of a court. When the potential witness takes an oath on his own, but if the oath is administered by others and those denying that they witnessed the incident in question neither take an oath nor answer amen to the administered oath, they are not liable until they deny any knowledge of the incident in question in court. This is the statement of Rabbi Meir. And the rabbis say, meaning the majority, whether one of the witnesses takes an oath on his own or whether the oath is administered by others, the witnesses are not liable until they deny any knowledge of the incident in question before the litigants in court. And one is liable for the act of taking a false oath with intent and for an unwitting act of taking a false oath. That is, he is unaware of the liability for taking a false oath, provided that he takes the oath with intent in terms of the testimony. That is, he takes an oath that he has no knowledge of the matter, even though he knows that the witness that he witnessed the incident. But the witnesses are not liable for taking the oath if they were unwitting in terms of their testimony. That is, they believed that they have no knowledge of the matter. And what are they liable for by taking a false oath with intent? They are liable to bring a sliding scale offering. So back to the Gemara. The Gemara says the Mishnah teaches that the oath of testimony is not practiced with regard to women because they are unfit to testify. The Gemara asks, from where is this matter that women do not testify derived? The Gemara answers, it is as the sages taught in a Braita, when the verse states, if an unrighteous witness rises up against any man, then the two men shall stand. So Deuteronomy 19, 16 to 17. It is with regard to witnesses that the verse is speaking. So apparently men, not women, may testify. And this is they're deriving this verse from Deuteronomy 19, 16 to 17. That it's men. Okay. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? When it states between whom the controversy is, Deuteronomy 19:17, the litigants are already stated in the verse. How do I realize the meaning of the phrase, then the two men shall stand? Apparently it is with regard to witnesses that the verse is speaking. And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, quote, the two men, and it is stated there on the basis of two witnesses, Deuteronomy 19:15. Just as there it is with regard to witnesses that the verse speaks, so too here it is with regard to witnesses that the verse speaks. The Gemara asks, what is the meaning of the statement of the Braita, and if it is your wish to say? Why is the initial proof inadequate? The Gemara answers, and if you would say that from the fact that the verse did not write, then the two men and those between whom the controversy is shall stand, which should indicate that the verse changes its focus from the witnesses to the litigants. Perhaps throughout the entire verse it is with regard to litigants that it is speaking. Therefore, the Tana cites an additional proof. So the Tana is from the Mishnah, cites an additional proof. It is stated here, the two men, and it is stated there on the basis of two witnesses. Those are quotes, the two men and quote, on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. It is taught in another Braita when the verse states, then the two men shall stand. It is with regard to witnesses that the verse is speaking. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention two? Do two people come to court for judgment, but three people do not come to court for judgment? And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, quote, the two men, and it is stated there, quote, on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. The Gemara asks, what is the meaning of, and if it is your wish to say, why is the initial proof inadequate? The Gemara answers, and if you would say that even though there are cases where there are more than two litigants, it is with regard to a plaintiff and a defendant that the verse is speaking. Therefore, the Tana cites an additional proof. It is stated here, the two men. It is stated there on the basis of two witnesses. Just as there, it is with regard to witnesses that the verse speaks. So to here, it is with regard to witnesses that the verse speaks. It is taught in another Braita, when the verse states, then the two men shall stand. It is with regard to witnesses that the verse is speaking. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention men? Do men come to court for judgment, but women do not come to court for judgment? And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, quote, the two men. And it is stated there, quote, on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so too here it is with regard to witnesses that the verse speaks. And the Gemara asks, what is the meaning of, and if it is your wish to say, why is the initial proof inadequate? The Gemara answers that it means, and if you would say that with regard to a woman, it is not typical conduct for her to appeal in court due to the verse that is stated with regard to women, all the glory of the king's daughter is within. Psalms 45:14. And that is why the verse addressed a situation that is prevalent. That is a case where the litigants are men, and there is no proof that women are unfit for testimony. Therefore, the Tana cites an additional proof. It is stated here, quote, two men, and it is stated there on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so too here it is with regard with witnesses that the verse speaks. The Gemara cites another interpretation of the verse. The sages taught, then the two men shall stand. That's a quote, sorry. Then the two men shall stand. This indicates that there is a mitzvah for the litigants to stand during the court proceedings. Rabbi Yehuda said, I heard that if the judges wish to seat both the litigants, they may seat them. What then is prohibited for the judges? They must ensure that there will not be a situation where one litigant is standing and one litigant is sitting, or a situation where one litigant says everything that he needs to say to present his case, and one litigant, the judge says to him, curtail your statement. The sages taught, the verse states, but in righteousness shall you judge your colleague. Leviticus 19:15. From which it is derived, the court must ensure that there will not be a situation where one litigant is sitting and one litigant is standing, or a situation where one litigant says everything and he needs to say to present his case, and one litigant, the judge says to him, curtail your statement. So alternatively, it is derived from a verse, quote, but in righteousness shall you judge your colleague, that you should judge another favorably and seek to find justification for his actions, even if when interpreted differently, his actions could be judged unfavorably. Rav Yosef teaches that from the verse, but in righteousness shall you judge your colleague. Excuse me. Amitecha. It is derived with regard to one who is with you, im she'itecha, in observance of Torah and in fulfillment of mitzvot. Try to judge him favorably in the manner that the Gemara will now explain. The Gemara relates, Rav Ula, son of Rav Eli, had a trial pending before Rav Nachman. Rav Yosef sent a message to Rav Nachman. Ula, our friend, is a colleague in Torah and mitzvot, with regard to whom the verse states that you should judge him favorably. Rav Nachman said, for what purpose did he send this message to me? Does he expect me to grant him preferential treatment? Every judgment must be undertaken with righteousness. So Rav Nachman then said, Rav Yosef sent me the message to ensure I would open with Rav Ula's dispute in the event that other cases come before me for judgment, in deference to the Torah because he is a Torah scholar. So, alternatively, Rav Yosef informed me that Rav Ula is a Torah scholar with regard to circumstances where the ruling is not clear-cut and the decision is rendered based on the discretion of the judges. That is, when the court is unable to rule solely based on the testimony presented in court and the judges arrive at the ruling based on their sense of the matter. So Rav Yosef informed Rav Nachman that if the case is decided based on judicial discretion, Rav Ula is worthy of having the decision ruled in his favor. Ula says, the dispute between the rabbis and Rabbi Yehuda with regard to the obligation to stand in court is only with regard to the litigants, but with regard to the witnesses, everyone agrees that that they testify while standing, as it is written, then the two men shall stand, Deuteronomy 19:17. Rav Huna says the dispute whether the litigants are required to stand is only at the time of the deliberation, but at the time of the verdict, everyone agrees that the judges issue the verdict while sitting and the litigants receive the verdict while standing, as it is written, and Moses sat to judge the people and the people stood, Exodus 18:13. The Gemara presents an alternative version of the statement of Rav Huna. The dispute whether the litigants are required to stand is only at the time of the deliberation, but at the time of the verdict, everyone agrees that the judges issue the verdict while sitting and the litigants receive the verdict while standing. As concerning the witnesses, the status of the stage of their testimony is like that of the stage of the verdict, and it is written concerning them, quote, then the two men shall stand. The Gemara relates, the wife of Rav Huna had a trial pending before Rav Nachman. Rav Nachman said, what should we do? If I will arise before her in deference to her status as the wife of a Torah scholar, the claims of the other litigant will be suppressed, as it will be mistaken as a display of preference for the wife of Rav Huna. Since not everyone is aware that one is required to show deference to the wife of a Torah scholar. And if I will not arise before her, that would run counter to the principle that in the terms of deference, the status of the wife of a chaver is like that of a chaver, who is devoted to the meticulous observance of mitzvot. So Rav Nachman said to his attendant, "Go outside and cause a duck to fly and cast it onto me, and in that way I will be forced to arise in a manner that will fulfill the obligation to rise without intimidating the other litigant." All right. The Gemara asks, why? But doesn't the master Rav Huna say the dispute between Rabbi Yehuda and the rabbis, whether the litigants are required to stand, is only at the time of the deliberation, but at the time of the verdict, everyone agrees that the judges issue the verdict while sitting and the litigants receive the verdict while standing. How then can Rav Nachman rise? The Gemara responds, one may fulfill both requirements in a case where he sits like one who unties his shoes, neither completely standing nor completely sitting, and says his verdict. So-and-so, you are innocent, and so you are guilty. So Rabba Bar Rav Huna says, in this situation where a Torah scholar and an Am Ha'aretz have a court case with one another, we seat the Torah scholar, and to the Am Ha'aretz we also say sit. And if he chooses to stand due to deference, we have no problem with it. The Gemara relates, Rav Bar Sharevya had a trial pending before Rav Papa. Rav Papa seated him and also seated his litigant counterpart, who was an Am Ha'aretz. An agent of the court came and kicked and stood the Am Ha'aretz on his feet to show deference to the Torah scholar there, and Rav Papa did not say to him, sit. The Gemara asks, how did Rav Papa act in that manner by not instructing the Am Ha'aretz to sit again? But aren't the claims of the Am Ha'aretz suppressed by Rav Papa's perceived preferential treatment of Rav Bar Sharevya? The Gemara responds, Rav Papa said to him that the litigant will not perceive bias, as he says, the judge seated me, it is the agent of the court who is displeased with me and compelled me to stand. And Rav Huna says, in this situation where a Torah scholar and an Am Ha'aretz have a court case with one another, let the Torah scholar not come to court early and sit with the judge in order to learn from him, due to the fact that by doing so, he appears as one who is consulting the judge to arrange his legal claims that is prohibited. And we said this only in a case where there is not a fixed time for the Torah scholar to study with the judge at that hour. But if there is a fixed time for him to study with the judge at that hour, we have no problem with it, as the other litigant will say he is occupied with his fixed study time, and the fact that he sat before the judge is unrelated to the case. Okay, and Rabba Bar Rav Huna says, in the case of a certain Torah scholar who knows testimony relevant to a certain individual, but it is a demeaning manner for him to go to the court, consisting of a judge who is less prominent than he in order to testify before him, let him not go and testify. So Rav Shesha, son of Rav Edi, said, we learn that halacha in a Mishnah, so Bava Metzia 29b, as well. If one found a sack or a basket, and it is not his typical manner to take it, he should not take it in order to return it to its owner. Evidently, a Torah scholar may refrain from performing the mitzvah to return a lost item, Deuteronomy 22, 1-3, if it is not in keeping with his stature. So the Gemara notes, this manner applies only with regard to cases involving monetary matters, but in cases involving ritual matters, the dignity of the Torah scholar is not a concern, as it is written, quote, there is neither wisdom nor understanding nor counsel against the Lord, Proverbs 21, verse 30, from which it is derived, wherever there is desecration of the name of the Lord, one does not show deference to the teacher. Rather, the Torah scholar forgoes the honor due him in order to avoid violation of any prohibition that would desecrate the name of God. The Gemara relates, Rav Yemar knew testimony relevant to the case of Mar Zutra. He came before Amemar, who seated all the witnesses in deference to Rav Yemar. Rav Ashi said to Amemar, but doesn't Ula say that the dispute between the rabbis and Rabbi Yehuda with regard to the obligation to stand in court is only with regard to the litigants? But with regard to the witnesses, everyone agrees that they testify while standing. Amemar said to him, this, meaning the witnesses stand during testimony, is a positive mitzvah, and that, treating Torah scholars with deference and allowing Rav Yemar to sit, is a positive mitzvah. And the positive mitzvah of deference to a Torah scholar takes precedence. So, Amemar seated Rav Yemar in deference to the Torah. In order to prevent a miscarriage of justice, he seated all the witnesses. Okay, the Gemara provides a mnemonic for the ensuing discussion. Advocacy, ignoramus, robbery, and fraud. So the Siman is Senegeron, Bor, Gazelat, Mirma. Okay, the sages taught from where is it derived that the judge should not engage in advocacy, or for his own statements and devise various pretexts to justify his erroneous rulings. It is derived, as the verse states, distance yourself from a false matter. Exodus 23, verse 7. From where is it derived with regard to a judge that a student who is an ignoramus shall not sit before him to discuss the proceedings? It is derived, as the verse states, quote, distance yourself from a false matter. When an ignorant student engages in the proceedings, he is apt to cause the judge to err in judgment. From where is it derived that a judge who knows that another judge is a robber and is disqualified from serving as a judge, and likewise a witness who knows that another witness is a robber and is disqualified from serving as a witness? From where is it derived that he should not join him in judgment or testimony? It is derived, as the verse states, quote, distance yourself from a false matter. So from where is it derived that a case where a judge who knows that the witnesses testifying before him are lying, even though he is unable to prove it through the cross-examination, and with regard to the verdict, the result will be that it is fraudulent, that he should not say, since the witnesses are testifying and I cannot since the witnesses are testifying and I cannot prove their deceit, I will decide the case based on their testimony and let the chain of culpability of miscarriage of justice be placed around the neck of the false witnesses. It is derived, as the verse states, distance yourself from a false matter. So the last part of that paragraph, it was in Daf 31, but that's it. So I'm going to try and catch up here for the holiday, and I'm going to be out for 2 days. So Shavuot 1 and 2, Monday and Tuesday. So I hope you have a great holiday. Chag Sameach. Yeah, have a lot of fun. Stay up. Try and stay up as long as you can to study Torah. Go through all the Torah as much as you can. The main points. Tikkun Leil Shavuot. So have fun.